All right, everyone, welcome to today's session, how to actually fill out an offer to purchase according to an attorney. Obviously, as real estate agents, the offer to purchase is one of the most important documents that plays a part in our business because it is the foundation of every single deal. And although we might fill it out all the time, there are details that can be really important when it comes to getting us to the finish line. And attorneys are the best point of reference for any questions we have, especially those intricacies. So today we're going to talk about all of that, the things that they see regularly as tripping points, how we can actually fill it out to set everyone up for success, and anything else we need to know in terms of do's and don'ts. Plus a live Q&A because like I just mentioned, if there was ever anyone to answer questions about any of our documents, it's an attorney. So Cara, thank you so much for being here today. If you guys don't already know Sterling Law, you should. They are a wonderful resource to choice agents. They are great at what they do. They have a number of offices around the triangle, so they can serve all of your clients no matter where they live. And they really pour into our community. So thank you guys for being here today. Kara, take it away.
Absolutely. Thank you so much. What an introduction. I love it. That's great. That felt so rehearsed and so good. I don't know how I'm gonna live up to your level, Kate. I mean, this is a lot. All right. So can everybody hear me? Good. All right, perfect. So, like we were talking about, this is how to fill out an offer to purchase and contract. You guys know how to do it, but there are so many little details and things that just come up that are out of the ordinary. And I can't tell you how many contracts we get that we need to get modified and get revisions on. And then you guys don't just have the offer to purchase and contract to think about. If the name of the buyer or the name of the seller needs revised, or even the property address, you have to fix not one, but go all the way back in time and fix every document that you've had these people sign. So that includes listing agreements, that includes agency agreements, all of the things. So we want to get it right from the giddy up. And in order to do that, a lot of times it's best to kind of communicate with an attorney that you're comfortable and you comfortable with, and that you want to be able to have that relationship. And I hope that's me that you reach out to, because I feel like I'm accessible. But what we'll do is we will start from kind of the beginning of the contract. So when we sent out the invite for the class, we said if you just wanted to have a blank offer to purchase and contract handy, that would be best. So if you have that handy, I'll give you a minute to grab it, just because we're kind of going to go through it from start to finish, just so you can kind of know where the issues that I find most are. So you know kind of how to approach them moving forward. So the first couple things, right at the top, the name of the seller and the name of the buyer. 99% of the problems that I find on a contract are there. It could be as simple as, did you actually put the client's full legal name? You don't necessarily always need first, middle, and last name, but if their name is Robert, don't put Bobby on the contract, because Bobby is not their name. If you didn't ask your client for a copy of their driver's license before you submitted an offer for them, that is a problem, because you will need to know what their actual legal name is before you get them under contract. That is one of the biggest things that we find. And it sounds very simple. And oh, how are people messing that up? But it happens so often. And if it's you, don't feel bad. I mean, you might have known your friend for years. This is a friend of yours, not a random referral, and you have always known him as Bobby. And so you just threw it on there as Bobby. It didn't even cross your mind to ask him for an ID because you knew who he was. But then when you submitted that contract, now his name's wrong, and now we have to fix it all. We have to go back in time and have all the documents revised. Also, and not just how a name is shown, what we have to worry about when it comes to sellers and buyers, especially, is also when it is not just a basic individual. The big problems always come when an estate is involved, a trust, any version of an entity, an LLC, a corporation, and a POA. So we'll kind of go through each one of those to kind of give you a good framework of giving you enough information to be dangerous, but not enough information that you might not need to call me because everyone is going to be different. So you're going to know enough to be dangerous, but then still call Cara, verify this is good before you put it on paper, and then everything's locked in. So we'll start with one of the easier ones, and it's the POA. When somebody has a POA, all it is authority to sign for somebody else. The POA owns nothing, is buying nothing. The POA is simply a signatory. Like all they're doing is signing for the person. So you will never put the POA's name as buyer. You will never put the POA's name as seller. The actual person buying the property goes as buyer. The actual human entity, whoever it is who's selling the property, goes as seller. The signature line is what is different. So when they sign for that person, they'll sign that person's name by their name, comma, attorney in fact, or agent, or POA, fill in the blank. It could be anything. That's not where the problems lie. The problems lie when somebody drafted a contract and put the buyer as the POA's name, not the actual person buying the property. You do not need to put the POA's name anywhere outside of the signature line. That's it. I know it makes it a little bit difficult with a lot of softwares that you guys use when I tell you, okay, well, here's how they need to sign. And it's difficult to fill that into Dotloop and DocuSign and whatnot, especially when it comes to what are the initials. Like you'll be like, well, the signature line says Kate by Cara, comma, attorney in fact. What are the initials? You can just have the initials be either the actual person buying or selling the property's initials, and the POA is putting those down there. You can put the POA can put their own initials on there, or what we do in a closing is you usually put, like, it would be Kate's initials by my initials, comma, AIF, which stands for attorney in fact. So it's just like a long way of putting initials. That would be gold standard, best option. But there's a lot of things that we can accept without having to have them re-executed. Like I said, it would be either just me putting my initials simply, or me writing whoever I'm signing for's initials. The initials aren't my problem. The signature line and how the names read on the contract are the sticking point problems that you have to fix. And at any point, if you guys have questions or tell me, slow down, Cara, you talk too fast, interrupt me.
I have a quick question, Cara. Just, I've never heard the term attorney in fact. Is that basically what every POA will sign after their name?
Yep, it's the legal verbiage that you usually see at the end. Sometimes you see them just write simply agent. Sometimes they say attorney in fact. Sometimes you can just see comma and they write POA.
Got it. Okay.
All of it'll work, but what we typically have seen is attorney in fact is usually like the fancy language that they're going to want you to write. That's pretty much it on POAs though. The biggest thing that I just want everyone to remember is you never write the POA's language as the buyer or as the seller. They are not buying nor selling anything. They are simply just signing for the person they have authority to sign for. Also, if somebody says, hey, I'm POA for my mom and I'm doing everything for my mom's in assisted living, my mom has dementia, all of the things, you're dealing with daughter the whole time, but mom is your client. Mom is the person selling the property. The POA is not your client. POA just simply has signing authority for mom. So you got to think about that as well. There's a lot of times where mom might not have capacity. We understand that the POA is there in existence, especially when a POA is involved. Always make sure that POA number one exists. It's not bad for you to ask for a copy of it. You're entitled to ask for a copy of it because everyone in the transaction is going to need a copy of it. The POA has to be recorded in the county that the property is located. So if the POA is not already on record, your client will need to have an original POA so it can be recorded. It's the only way that it can be valid. Especially if you have a client, like I said, when it's maybe mom is the seller, mom has dementia, mom's in assisted living, mom doesn't have capacity, it is vital that an attorney see that POA to verify that there is durability language in that POA. What durability language is that the POA was signed when before mom had dementia or mom got too far gone. The durability language says that the POA can continue to be in existence and continue to be valid upon subsequent incapacitation. So once mom no longer has capacity, that the POA is still valid. So that is very important that that language is in there, the durability language, especially if your client does not have capacity. So before you get to the point that you are throwing up listings, getting under contract, all of the things, have that POA reviewed by an attorney just to make sure that you will be good. Sometimes it also may or may not have language that the POA has authority to buy or sell property, mortgage property, all the things. If that language isn't in the POA is worthless as well when it comes to buying and selling real property. So we have to be sure that everything in that POA has the proper language. So ask for a copy, have it reviewed, make sure that it's recorded. If it's not recorded, they need to have the original. So they may have to dig it up. They may have to find out if the attorney who prepared it has the original on file, a number of things. And if it was drafted in another state, that is fine. It just needs to especially be reviewed now to make sure that the proper language for a North Carolina transaction is in there, which would be capacity language, information that they can buy or sell real property, all of that. And especially too, if it was maybe prepared in New York, do they have the original? If not, does the New York attorney have it? Basically all of those things. So ask for a copy of it prior to signing anything. Kind of to go along with the POA, asking for copies of everything when you are then dealing with an entity. So your buyer or your seller is not a human, it's an LLC or an S Corp or just a regular corporation. The entity is your client, not the individual who called you. So if the property is owned by the entity is who is selling the property. You need to know who has proper authorization to sign for that entity. If the person who called you is the one who is talking to you, wants to sell the property, everything, you pull up the deed and you're like, well, it's actually owned by XYZ LLC. Or who are you with XYZ LLC? They might say, oh, I'm the manager. Great. Prove it. Send me the documentation, because you want to make sure that the proper person signs everything. I can't tell you how many contracts I get signed by one person. And once I finally get to the point that I've received the documentation necessary to know who has authorization to sign for that company, it's not one person that I need, it's two people. So I have a contract signed by Joe. All of my deed, everything I need for the sale actually needs signed by Joe and John. And then that's when people start getting mad. It's like, well, John's not here. And then everyone starts having to double back. So what you need for an entity is what's called an operating agreement. Anything. Corporate documents. Do you have an operating agreement? Do you have a signing resolution? I can give you all of the kind of phrasing, verbiage. They might know it as something different. It is not always what is just found on the Secretary of State's office. What is filed with the Secretary of State is enough to be dangerous, but is not enough to be what we need in order to actually verify everything and certify title and convey title. Because a lot of times they won't have operating agreements on the Secretary of State's office. They have registration documents. That doesn't help me. I need to see their actual corporate documents that show who has signing authority, who the members are, if it's member managed, if it's sole member managed, or if there's multiple members. And it can be structured in a multitude of ways. So we need to verify those things. And if you get that information from the beginning, you're setting proper expectations for that client, because people are going to be asking for it. And if I'm asking for it after they've already been under contract for 2 weeks, Then everyone's like, why am I just getting asked for this now? And you could have kind of headed that off by getting that before they even went under contract. So then you're also helping me and helping you. It's like, oh, I told you you'd need that. I already have it handy. I'll get it to the attorney. No problem. We've already verified that everybody who has signing authority has already signed it. You're good. But you can also start a conversation early on as well when you might only be talking to Joe. You see the documents before you go under contract that the operating agreement says the members are Joe and John, and it's member managed. That's when you could talk to Joe and say, hey, your operating agreement has both of you on here. If you want to be the only one to sign for everything, you can, but we need to get a signing resolution in place before we go down that road. And that's a way to head it off again that maybe one of the member managers is just traveling or not able to pin down or anything, a number of things. You can kind of prevent the catastrophe at the end that we need this other person to sign everything and we have to double back and get them to re-sign the contract and all of the fun stuff that nobody wants to do. Head that off by getting all that information up front. That's the biggest thing I find with entities when that happens. So also make sure you sign the entity signature side of the contract, not the individual side. There's two different signature lines. So when you're looking at the signature page of the contract page, it always changes because we keep adding numbers, probably page 37. Nope, just kidding. Page 12 is the signature page. And you want to sign where it says entity buyer or entity seller, not where it's the individual. I know there is only one signature line for entity buyer. I get this question a lot. Hey, Cara, there's two people that have to sign for the entity. There's only one entity buyer signature line. Fit it in however you can. I mean, it's okay if both signatures are next to each other. You guys create the boxes anyway for the e-signatures. It's fine. As long as I see two signatures on there, if they're on the same line, it doesn't matter. However you guys can make that work. Same thing goes when I'm talking about entities. Same thing goes with trusts. So the trust, when somebody conveys property into their trusts or bought it in the name of their trust, the trust owns the property. Everything, your client is listed as the trust. They are the vested owner. They're the ones purchasing the property, or they are the current vested owner of the property. You need to see a copy of the trust in order to determine who has signing authority for the trust, just like an entity. A lot of people tend to be a little combative on providing somebody a full copy of their trust. There's a lot of private information in there, and you will see that you may get a little kickback when you're asking for a copy of it. I technically don't need the full thing. A lot of times when people have complicated trusts, they have what's called a certificate of trust. The certificate of trust has all the information that I need on it. It says when the trust was created, is it revocable? Who are the trustees? Has it been amended? That's the stuff that I need. I'm not looking at a 100-page document of their trust and scouring through and be like, oh, you're giving that kid that much and that kid that. I don't care. I don't have the time to look through it. I don't want to look through it. I'm looking basically for who has authority to handle this transaction. Who are my trustees? Is this revocable? When was it created? Just the stuff that I need. So if your client is a little combative or a little hesitant to provide you a full copy of their trust, ask them if they have a certificate, or just say, hey, let's send the attorney the first couple pages, see if those first couple pages have the information they need on it. They'll probably want to make sure it's been executed. So maybe send the first couple and the last couple. And then I can get what I need in order to handle the closing. But again, your trust, make sure everyone who has authority to sign for the trust signs all of your documents. If there are two trustees, you need both trustees to sign everything. That's how it operates. What I've come across most recently when it comes with trusts is kind of just a lack of understanding of what happens when somebody dies and the property's in the name of a trust. The reason that a good reason people transfer property into their trust while they're living is to circumvent certain things to happen upon death when it comes to making things more complicated for people once you die. So going into the trust is supposed to make things less complicated once you die. So the trust survives your death. If I transferred all of my property into my trust and then I died, my trust still owns the property. You're not wondering, well, who's Cara's heirs? Is it her kids? Is her husband? Does she have a will? None of that matters. If it's the Cara Gibbons trust and I am now dead, Cara Gibbons trust still owns the property, and my trust document itself will tell you what happens when I die. I'm no longer the trustee. There's what's called a successor trustee who handles my property now upon my death. I put in there my successor trustee is Michael Gibbons. So now Michael Gibbons is the trustee of my trust. It triggers a lot of people's like, well, she's dead. What, like, it doesn't matter. The entity owned my property. I didn't own my property. So you don't have to worry about when it comes to the estates, heirs, questions upon anything. None of that matters. The trust itself will tell you who the successor trustees are if the actual trustees have now passed. Makes things a lot easier. So it's one of those things too that you can tell a client. So say the kids are calling you, they want to sell parents' property. You pull up the deed, the parents were very proactive. They put the property in the name of their trust. Now you don't have to worry. This property passes fully outside of everything else they're dealing with when it comes to probate and dealing with their parents' estate. Property is owned by the trust. What's the trust say? Who's successor trustees? That's who you need to sign everything. Now that we talked about people dying, the worst of it all, the estates. This is where we see 90% of our problems come from estates. I'm looking at a contract right now in front of me that I got yesterday or the day before, and I printed it off and I'm using it as my example to go through the OTP with you guys. And my seller is listed as two people's names, and then in parentheses it says heirs. No, that's not right. We don't want to do that. So I don't know if the two names that are listed on here are the dead people. I don't know if those are the heirs. I don't know. So I'm going to have to look into that. We'll find it when we pull title. Hopefully they are the heirs. If they are the two names that are listed here as seller, if they are the heirs of somebody who passed, we're kind of going in the right direction. But I might be missing people. I'm probably missing spouses of these heirs. I'm also potentially missing an executor of an estate, because if the estate is still open, I should have needed that as well. So basically, from just, again, enough information to make you dangerous. When somebody dies, immediately upon death, their heirs own the property. Heirs are determined two different ways, either by what you put in your will, or you don't have a will, intestate succession laws mandated by the state of North Carolina. If they have a will, great. First thing is you look in the will, who gets the property upon death. Easy peasy, it's this person or these people. Your sellers then would be those people. It would be those people, their spouses, if they have them, and the executor of the estate if this estate has not been opened yet or is in process of being opened. When I say open the estate, you might also hear the phrasing probate the will. Very similar. It's basically the same thing, but that's what's happening. That's the structure of everything. If you die without a will, usually you're looking at, did they have a spouse, children, no spouse and children. You're looking at parents. They didn't have, their parents are deceased. You're looking at siblings. Kind of goes down a family tree. What you're doing, though, is from your perspective, it's not your job to determine who their heirs are. It's not your job to determine if the estate has been probated properly, if the estate is open, if the estate is closed. You just need to know the questions to ask to then determine a path forward. So you're in a listing appointment. You're with these two people, they say that they are the heirs of their parents who passed. Great. Step one. All right. When did your parents die? Then they'll tell you. Do you have any other siblings, or did they have a will? If they say, yeah, they had a will and the property goes to me and my brother, wonderful. Has the estate been opened? Or have you already closed the estate? Because if they're reaching out to you now and their parents died 5, 10 years ago and they're now just getting around to selling the property, the estate is probably closed. So at that point, the estate isn't involved in the transaction, just the heirs are. So it takes people out of the equation on who you need to sign things. But you're asking startup questions to then know, okay, now I'm going to call Cara. I'm going to tell Cara what they told me. She could take a look at public records. I can look and see, okay, well, the deed was in the name of mommy and dad, and they had it as tenancy by the entireties. They owned it together as husband and wife. Dad died 5 years ago. Mom died last year. All right. So now I need to know who the heirs of mom are, essentially, because mom was the final survivor. So I can help guide you through it, but getting those initial questions answered first. And you're like, okay, well, I was talking to Joe and Jim, and I can look and be like, oh, okay, Joe and Jim were her sons. This is all tracking. Like you already were talking to the right people. Now you just need to get this, and this checked. Once you get these answers, these are the additional people that you're going to need to sign. And I will give you a beautiful statement of how you should list the seller on the contract. And you just copy it, paste it. That's it. So you don't have to worry about thinking. I just gave you how it'll be listed, and then you move on from there. What throws people through the loop a lot is when there's more than two people you're dealing with. It's like, all right, Cara, I have 6 people I need to sign everything. And I'm like, that's a lot of people. What the best route then is, a lot of people always ask me, well, should I get POA for them, so only one person has to sign everything? That makes things, quite frankly, in my opinion, a little bit more complicated and costly for them. When you're saying, okay, there's 6 people, now I need 5 of them to give POA to one. We're drafting 5 POAs, we're recording 5 POAs, where then it just makes things more complicated. The only way I really push for a POA for one of the heirs, so the other ones can sign for them, is if one of the heirs is leaving the country or just completely uninvolved. Very difficult to pin down, that kind of thing, because people don't like to spend money, frankly. And as soon as you say, all right, these POAs are $200 a pop, now you got to pay that, then the recording fees and all of this stuff. And they're like, well, all of this so I can give my brother the authority to sign this. And then people start not trusting their siblings. And then you got to get into all the family dynamics. And then it just becomes one big cluster that you don't want to be a part of. So it's, when you see the 6 people, you can tell them, hey, listen, like, I know that the sister here is driving the ship. She's the most organized. She's the one I'm talking to. You guys are just along for the ride. Make sure sister is the one signing the OTP, and then use your additional signature addendum and have everybody else just sign that. Like, that's how you can be like, not having to have, because really you're not going to have more than 2 people sign the OTP anyway. Use it for the one person that is doing all the work, and then do the additional signatures addendum for everybody else. And then they're signing one thing that incorporates everything else. What I want to kind of also touch on when it comes to sellers and buyers, especially when they're not individuals, make sure they have their EIN number or their socials handy from the beginning. When it's an entity, especially an LLC, a corporation, even a trust, they should have an EIN number for that trust. They should have a tax ID number for their trust or their entity. If they don't, sometimes with trusts they don't, which that's okay. It's usually then their personal social security number. But I can't tell you how many sellers tell me, oh, I don't have an EIN number. Sure, You sure do. I promise you do. So we're going to have to find that. We come across this a lot recently, and I don't know if it's just people being people. People just tend to be combative at different times. Um, Asking sellers, especially now, for their social security number or their EIN number, very, very hesitant to provide it and always want to know, well, why do I legally have to provide it? Like, do I legally have to give my social security number? The answer is yes, 100%. Like, there is no way around it. If you're going to sell property, I have to issue a 1099. Only way to do that is with the tax ID number. I also likely have to order payoffs. The only way I can order those is with your social security number or your tax ID number. Um, you have to provide it if you are selling property. Also for FERPTA purposes, I need to know if you are a foreign person, and I need a social security number for a FERPTA affidavit. So there's a multitude of reasons I need a seller's social security number or an EIN number. So help me help you. If you already have given them that information, that is something that they're going to have to provide in order to sell the property, it helps, because I can't tell you how many times I ask for it and then a listing agent will join in with the seller on the reasons why I don't need it, which are none. I need it for a lot of reasons. So when they got a hype man in their corner giving them bad advice, it doesn't help me. I know that's a lot of information to digest, and I know I talk really fast. So is there any questions just on buyers, sellers, how names should read, that kind of thing? All right. You guys are so smart. I love it. You're like, Cara, you're telling me all this stuff I already know. It's never my choice agents that are my problem children. I won't tell you who my problem children are, but they definitely don't work at choice. All right. Next up, when we're going down the OTP, it is the property. A lot of times it's very easy for you guys to get the information for it to fill in the property, the street address, city name, lot number, plat, book and page, all of the things. You pull it from the most recent deed, and you tend to get all that information. And if you're not looking at the most recent deed, you're at least pulling it from the tax records, and it's good. The problems that I find when I'm getting contracts that have the property address wrong or issues with it to where we need to change the contract or modify it later tend to be when there may be multiple lots involved, or there are, if you guys do some business out in like Johnston County and stuff, when there's a separate septic field lot, or there's two under one tax ID number, or we're conveying two different tax ID numbers, that two lots that haven't been recombined. The clarity on the contract really, really helps us do the title examination. The more information that you have on there telling me what you think you're buying or telling me what you think you're selling, it really helps, because sometimes I just get a street address, and if it says 0 Main Street, it happens a lot with vacant lots. That doesn't help me. I want to know what you think you're buying, because very likely if you think you're buying 0 Main Street, this is old family land. It might have been cut up over time. We're looking at, you think you're getting 16 acres, but the vesting deed's from 1927 and it's 125 acres. Where did this little 15-acre piece come out of? So it helps us better identify what we are then doing a title examination on and what you think you're actually buying. So the more information, the better. And if it is one of those odd pieces of vacant land, or if it is something that has two separate lots, or you're buying a septic field as well, or the property that the current deed has multiple tracts on it, the seller bought 3 different tracts and now they're only selling one. Had it happen recently where a client bought 2 neighboring lots in Durham. One, the house is sitting on one, and then there's one next door that's vacant. He bought lot 10 and 11. Now he's only selling lot 11. And so they were taxed together. They were taxed as one, lot 10 and 11. So if they just gave me the street address, because it only has one street address, because the house is sitting on only one lot, I could have conveyed both lot 10 and 11 if there was not clarity in there. And let me tell you, there was not great clarity on the contract that we got. So we asked a lot of questions to make sure, are you trying to sell both? Are you keeping one? What are we doing here? Because essentially we also have to have conversations then with the tax office saying they're currently being taxed together, lots 10 and 11. My client's only selling lot 11. Are you going to give the other one a new tax ID number? Do we have to do a split? Do we have to file paperwork? What are we looking at here? So want to make sure all of that is clear and that gets moving along properly. Any questions with the property address or how to fill in property information? Yes, no, maybe so. Nope. Cool. All right, moving on. The money
Actually, real quick,
Actually, I'm
Cara.
sorry. I do have a question.
Yeah.
I know what I usually fill in on. I'm Diane, by the way. I don't
Okay.
think we've met. You helped me this week, so thank you, via email. But I know what I always fill in for the property address in terms of like the PIN, and I try to fill out whatever I can. Sometimes though, I see people leaving things out. Is there something that should not be left out ever? Like, is more better than less?
More is better than less.
Okay,
I would not leave out lot numbers.
right. Okay.
Lot number. The only time you're leaving that out is if there is not one. If it's just a meets and bounds description, doesn't actually say a lot number.
Yep.
Definitely would not leave out the PIN. Your tax.
Okay.
So my biggest thing would be obviously street address, lot number, and PIN number. Plat references and deed references, they could change. There could be a new plat recorded. You might find one plat reference and then it's different. You could, but again, more information is better than not enough. But the things that I definitely would not leave out would be your lot number and your PIN number.
Okay. Thank you.
You're welcome.
Cara, can you expand on that? I've seen parcel ID number and PIN number, and sometimes there's little variations between the different numbers available to us to choose from. Which one are we wanting?
Every county calls it something different too. So I understand where you're coming from. So like in Wake County, you'll see the real estate ID number, you'll see the PIN number, you'll see like 3 different numbers. Any one of those will make me be able to identify it. So that is fine. Like Orange County, they have a special PIN number, which is a little different than what they call their parcel. So every county is a little different. Whatever you can find, though, I will pick up what you're putting down. So you put it on there, I'll be like, oh, I know where she found that. And then I'll double back on it. So as long as you're pulling it from the tax website or from prior deed, I'll know which one you chose. So it's okay to put kind of whichever one you're looking at. In Wake County, especially though, if you're asking me for my preference, in Wake County, I like the real estate ID number.
Okay. Thank you. Your example in Durham reminded me of a transaction that I had that I'll share just a little piece. I helped somebody buy 2 lots that were next to each other. It all went on one offer to purchase, and they were getting a mortgage at the time that they purchased it. And so when they purchased it, the mortgage lien on the property ended up being applied against both of the 2 properties since it was all together. And so fast forward into the future, they were thinking, should we sell the lot and keep the house? Should we sell both parts together or separately, and all of these things? And that's when it came to light when we realized, oh, this is a little bit stickier than we realized. They can't just cut off the lot and sell the lot all by itself, because the deed of trust included the lot as well. So for my sellers, it ended up working out. They ended up selling both properties, listing both properties at the same time. And the one with the house on it closed first, which removed the deed, the lien on the lot, so that then the lot could close. But I just mentioned that because I think sometimes we don't think ahead into the future, the consequences of how something may have been structured at the time of a purchase. Or maybe it's just a different agent that's handling that part of the transaction, so.
Yeah, absolutely accurate on that. So when if you want to sell that vacant lot next door, but the lien is against both, you can get the lender to release the lot. But a lot of times they're hesitant because they want to keep as much collateral as possible for the amount of money that the client borrowed. So that is definitely something to be mindful of. But that also makes you a really good agent when you can have those conversations where you're like, oh, you want to sell that lot? Do you have a mortgage? Like, because somebody else might not have asked them that question. They might have just been like, "Oh, I got a listing. Let's list this vacant lot. Let's make you some money." And then it gets a little bit wonky. And then the last thing you want is to find that out when you're already under contract and not where everything happened. Any other property questions?
Cara, I have just one, just to clarify. It's Desiree, and thank you for this. This is great information. So oftentimes, in the MLS, you'll see property for sale, adjacent lot, 401A or whatever. So in that, we would just pull the tax for both and property description, list both, and like in parentheses, that obviously either the PIN number or the real estate ID number for both.
Yes.
Okay.
You put them side by side with an ampersand, make sure it references both PIN numbers, both lot numbers. That way there's no ambiguity. It's very clear what they're buying and what they're selling. So the seller can't come back and be like, no, I only said I was going to sell one lot. It's like, nope, you signed a contract and have both on here. We're getting both of those babies. So yeah.
Thank you very much.
You're welcome.
That brings up another question for me, and if we need to set this part of the conversation aside for another time, that's okay. But what happens in the event where multiple properties are being sold together as a package? If it's more than two, they might not all go on one offer to purchase. And so then the question is, how are they all linked together so that somebody doesn't end up just running off with only one of them when they were all supposed to stay together?
Yeah, so there's a little box on the OTP that says additional parcels. So if you can't fit everything in there, you could check the additional parcels. And it says if additional parcels are subject to this contract, any parcels are described in an exhibit to the contract. So you can always attach another exhibit A that lists everything. So you don't have to have multiple contracts for multiple parcels. If everything's in a package deal like you're talking about here, and maybe they're getting 6 different lots, they all have different street addresses. They all have different PIN numbers. It makes it a little difficult to have everything right on page 1. Check that parcels box, and then you can take the legal description from the current deed. If they bought all 6 together, now they're selling all 6 together, just take that legal description, slap it on there. But also if you like, it is best to run that by someone like me and be like, hey, I just want to make sure that we're not going to kick ourselves here if the seller thinks they're going to get away with us missing that one extra lot or something. You don't want to have to double back and be like, well, we thought we were buying all of this. And then the listing agent's like, well, no, you only asked for 5 of the 6. We're only giving you 5. Want to make sure it's all encompassed in the contract.
Perfect. Thank you.
All right. When it comes to purchase price and deposits and everything, the only time I really see a mistake there, you guys are good with money. The only time I see a mistake there. I muted myself and we're back. The only time I see issues when it comes to purchase price is when people utilize my really fun staggered due diligence addendum. So if you're doing staggered due diligence or any sort of modification of existing deposits, you will put, so say it's $1,000 at effective date, and then after maybe appraisal, after home inspection, or whatever, you're giving an additional $5,000 of due diligence. You put the full amount on page 1 of your contract. So you're going to put $6,000 of due diligence on the contract. If $6,000 is going to be what your final due diligence amount will be. The addendum that goes along with the staggered addendum specifies how that $6,000 is going to be split up. but page 1 of the contract should show the full amount. So that's where I see some issues, or people try to get kind of creative, and then they put like, they just start making it look real wonky. Like they put one by, like make it look all weird. You don't have to go there. You don't have to do all that. Just keep it as showing the full amount of DD on page 1. The addendum will specify otherwise. The question comes a lot too, is like, well, if I put $6,000 on page 1 and they end up terminating before that second part of the staggered DD is due, are they now due the whole $6,000? The answer is no. The addendum specifically says that additional due diligence is not going to be due until a triggering date. If we terminate before that triggering date, that money is never due. So the addendum will support you in that, to give your client that kind of assurance that we have to show the full amount on the contract. Don't let that confuse you. Our addendum will protect your money otherwise. And I have been seeing staggered due diligence recently too. So I guess people are liking that again. So if you want that addendum, let me know. I can send it over to you so you have it in your little arsenal when you're out there shopping. Next up is seller concessions. I know that this was kind of a big trigger point for people once this changed back in the summertime when we got our new contracts, when they made this revision. I'm not seeing any problems with it. I think everyone's finally wrapped their head around it. Your concession is either a percentage or a dollar amount, not both. So just be mindful of that when you're filling it in. If you are doing the concession, that you put it in properly, especially if they are saying they're covering your commission or however that's happening, because we're going to see that percentage number used most of the time when it has something to do with compensation. So if the seller is providing 3% and that's going to cover commission or whatever, just be careful when you're filling that in. But I'm not really seeing a lot of problems with it. I think a lot of those have been kind of hashed out over the last few months. But if you have any questions on that, let me know. But that is definitely not something I'm seeing as an issue right now. What I do see as an issue is our next two friends, our due diligence period and our settlement date. What I see when it comes to due diligence and settlement dates is just people just maybe not having the forethought of thinking like, what day is a day. I can't tell you how many contracts I got with the settlement date as Martin Luther King Day, or the settlement date as another federal holiday that just everything's closed. Just be careful with that. Look at the calendar before you're writing contracts, because if it's on a federal holiday, we can't close. Banks are closed, register of deeds closed. So my office is probably closed. So just be mindful of that. Don't put it on a holiday. When it comes to your due diligence period, this is just like a PSA. Don't put your end of due diligence on a Sunday or even a Saturday, frankly. That's not helping anybody, because if you need to get somebody on the line on a Sunday, I'll answer my phone, but they'll put us in that situation. Let's be mindful. Let's have the end of DD on a business day. A lot of times too, that also triggers money being owed. Money can't be exchanged on a weekend. You want to give your client the best ability to have all of the information, all of the resources at their disposal. And if you set them up by having due diligence end on a weekend, you're limiting their, sorry, and I'm back. You're limiting that ability for them. The other thing I'm a huge not a fan of is whenever somebody puts the settlement date as like 30 days from effective date. Yes, you can, but no, you should not. As soon as you start putting numbers down, nobody remembers how to count. Everybody forgets how to count. Like at this point, we're like 30 days from effective. Does 30 days start here, Cara? Or what does it start on this date? What's 30 plus 5? Like, please, let's not get into the counting battle. It's way easier to just put an actual calendar day on there. And that way nobody's questioning when this 30 days starts. Do we count the weekend? Do we not count the weekend? Do we count Christmas? Do we not count Christmas? Let's just not do that. I do tend to see, and I understand the thought process behind when people are working with short sales, or they're working with maybe reload companies, and they say such and such number of days from effective date because they know it might take a week for the contract to even get executed by reload or even get executed by short sale. I understand that you don't want to cut days off of your client's due diligence. You don't want to cut days off yourself. You don't want to harm your client because you want the days to start upon effective date. If you're in a position where you know it's going to take reload a week to get back to you on your offer, you know it's going to take short sale a week to get back to you on your offer, factor that in when you're putting your numbers down. Just factor that in from the giddy up. Don't just throw 30 days from effective date. I actually have an agent who always does 30 days from effective date, and it drives me bananas. Don't tell her. But it drives me bananas. Putting dates is a lot better because then we have no questions. Everyone remembers how to count, and we are good. Any questions with that? That was all page 1. 50 minutes of page 1. I will say the rest of the contract, though, there's really not much that we have any issues with. So what I love about the new contract is all the important stuff is on page 1 now anyway. So we're good. I will say with the last couple minutes of the call, before we throw in some Q&A at the end here, the only other things that people tend to have issue with is filling in personal property. Just be really careful if certain property is going to convey or not convey. Just be really clear what those items are, because you just don't want to have any question at the end. I had a client recently that they just put in the thing, all pool equipment. All pool equipment was way too subjective because in their mind, they were getting like lounge chairs and umbrellas and stuff. And in the seller's mind, they were giving you the vacuum and the skimmer. So there was not a meeting of the minds on what all pool equipment was. And I had to fight for my client to get a freaking lounge chair. And granted, I feel very vindicated because I won, but like, I didn't go to law school to fight over lounge chairs. So just be really clear on what it is. Just that you don't want any subjectiveness when it comes to personal property. And then the only other thing really on the offer to purchase contract I want to hammer in is page 6 when we're asking about other property. And do you have to sell another property in order to try to make it contingent, not make it contingent? The offer to purchase is merely an FYI when it comes to contingency for selling another piece of property. You want to be forthcoming with your offer and say, yes, I do have to sell another piece of property in order to buy this. Has it already gone in the market? Yes or no? All of the things. But that does not protect your client, the buyer, in any way of getting any money back or getting out, not being in breach, nothing by just filling this in. If you want the contract to truly be contingent upon the sale of another property to where there's automatic extensions already being granted or earnest money being refundable, anything for that matter, it needs to have a subsequent attorney drafted contingency addendum. And we can make that custom fit. There's not a one size fits all contingency addendum. There used to be years and years ago with the real estate commission. They got rid of that years and years ago. And then they modified the contract accordingly. We can give your client and what would make the seller get the warm and fuzzies, all the things we can custom fit that contingency addendum that protects the client, but then also gives that seller the assurances they want as well. So just be really careful because I'm still, unfortunately, getting contracts where they check the box, I do have to sell. They checked all the things on the contract and they thought that the contract was now contingent. And when we couldn't close on the settlement date and the seller was unwilling to give an extension, it was not a good conversation to have with the client. That you lose all your deposits, you lost everything. And they're like, but I told him I had to sell. It's like, yeah, you did. He didn't care. Like that you got to be careful with that. So that's the only thing I would say when it comes to that is just be really careful on the contingency language and understand what that means to be able to relay that to your client properly. And if they really do want it contingent, you can make it contingent, but you need me. You need an attorney to draft it so they can be fully protected. Don't want to take up, I know we said an hour, so we are close to the end of time, everybody. Does anyone have any questions? You got me. Free legal advice for the next 5 minutes. Clock it. No free legal advice.
I have a question.
Oh.
Since I'm still new and I'm learning all this, when things come up or when you have questions, how does that work? We call you and you bill us, or like, how does this work?
No, call me anytime. There's a lot of people on this call that I know can attest. Please feel free to reach out. What I enjoy most is being a resource. I love teaching. I love chatting. It helps me help you. So whenever if you're in a pinch, let me know. And I can help answer your question. Shoot me an email, give me a call. I'm pretty accessible when it comes to that kind of thing. So no question is a dumb question. Feel free to ask. And I can definitely help guide you. So feel free to give me a call if you're going through something, you have a question.
Okay. Hey, Cara.
Yes.
It's Rosemary. Hi.
Hi.
So question for you. What should we be looking for on a deed when, I guess I just need to know this for sure, but I know like in North Carolina, when you're married, both names on the, if both spouses are on the deed and one passes, it automatically, becomes the other spouse's house, correct?
That's a great question, Rosemary. And I'm glad you actually brought that up because it has to have something in there referencing that they're married. So in order to get the tenancy by the entireties, which is what you referenced, that when one spouse dies, the other one gets it outright, no questions asked, don't have to have probate, nothing. It has to say specifically that they are married. It can say and spouse, and wife, and husband, a married couple, however you want to phrase it. But if it doesn't say that and it just says Cara Gibbons, Mike Gibbons, the presumption then is that we own it not as a tenancy by the entireties, but as joint tenants, which creates a lot of problems. So it's a drafting error that could be detrimental to people. So what you're looking for is the language in there, it just referencing that they're married to each other, or it can even say tenancy by the entireties. I highly doubt it will say tenancy by the entireties because the presumption is if you say and spouse, you get a tenancy by entirety. So it's redundant to say Cara and husband Mike as tenancy by entireties. I just look crazy if I was drafting that document. But what you're looking for is make sure that it says that they are married. And then that's how you can know, okay, your husband died. All you're going to need is a death certificate. That's the only thing you'll need, and you're good to sell.
Okay, thank you.
Yes, absolutely.
Cara, I had, oh, sorry. Go ahead.
Just on that topic really quick, if we know for a fact that ours doesn't say that, is that something we should address? I'm like thinking personally, I know that the title of my home is just in myself and my husband's name, and it does not state us as a married couple.
Oh, no. You got fix it, call me. Send me a little DM after this. It's an easy fix. You just convey it from yourselves to yourselves, but you're going to add that language in there. So now not only do you have the protections of the tenancy by the entireties for the survivorship language, that what happens if one of you dies, you also have judgment lien protections in North Carolina. So we're going to add all the little protections that you get as a married couple, but that's a great thing. Everyone pull their deeds to their house and see if their deeds messed up. Make sure that it has it on there properly. Little story. The fact that you brought that up, I actually had clients who bought a house together when they were engaged. They weren't married yet. They specifically told the attorney, at least this is what the spouse told me, it specifically told the attorney when they bought it, they were engaged, they wanted right of survivorship because you could put on there as joint tenants with right of survivorship that helps if one of them dies. It was a young couple. The husband died in a car accident. By the time he died, they were no longer engaged. They were actually married, but they never deeded the property from themselves as an engaged couple to themselves as a married couple. And the attorney that helped them when they bought forgot to put joint tenants with right of survivorship. So this poor woman owned the property after her young husband died with her 1-year-old daughter and his parents that she did not have a good relationship with. So
Oh my gosh.
very young, he didn't have a will, and it was a very complicated, unfortunate, and unfortunately expensive situation that she had to go through because of a very simple drafting error. So pull your deeds. If you want to have a little like, hey, I want to do a little touch base with all of my previous clients, give them that advice. Hey, I love you. Happy Valentine's Day. Pull your deed and see how you own title. And if it doesn't say you're married, call me. And then we can fix it.
Yeah, myself and my husband, we have different last names. I never changed my maiden name when I got married. I preferred to keep my birth name. And so it's always something that we come up against, like whenever he tries to put me on his health insurance, they make us give our, marriage certificate and all the things because our last names are different. And I'm wondering if that probably had something to do with it.
It could have. They just assumed that you weren't married. Though I'm glad you said that too, though. Names don't matter. So if you had a client that changed their name after the fact, unless they absolutely refuse to see a tax bill with their previous name on it, there is zero reason to change your name on your deed. Marital status triggers things legally. Names don't. You just have a fancy formerly known as or also known as when you go to sell. So you don't have to actually spend money to change your name on a deed. If an attorney tells you that you do, they're just trying to take your money. Don't waste your money just updating your name. If you already were married when you bought it and then you changed your name after the fact, as long as your marital status has not changed, don't worry about it.
Cara, I just kind of would love your opinion on this. What are your thoughts on having the buyer and the seller use the same attorney for closing, like drafting docs?
Yeah. So honestly, it's a lot of preference. When it's different when it comes to properties around here, like around the triangle. And then I get a completely different experience when I deal with properties in like the Sandhills or Pinehurst, Southern Pine, Fayetteville. In Southern Pines, Fayetteville, and all that, they have always been of the mindset, and their standard practice is the seller has their own attorney and the buyer has their own attorney.
Okay.
Around the triangle, around here, I want to say it's pretty much been the standard practice that it all happens under one roof. That's
okay.
But that doesn't mean that you have to do it one way or the other. I tend to like when you have your own representation. Things are a lot more adversarial and combative nowadays than they were a few years ago. So when the seller has their own representation and the buyer has their own representation, everyone seems a little bit more protected because you have someone in your corner who's looking out just for you.
Okay.
I can't represent both parties. So even if it's happening all under my roof, I only represent the buyer. If something happens in the seller, if there becomes a conflict, I'm preparing the documents for the seller, but I don't represent the seller. So the seller starts calling me and yelling about stuff. I have to be like, well, I don't represent you. Please stop talking because everything you tell me, I'm telling the buyer. So you got to be thinking about that when you're talking to your client. And having two separate attorneys is fine. It actually happens all the time. A lot of people then have the preference of having it all under one roof. It really just depends on what you want. It doesn't cost the seller any more money to have their own attorney. They're going to either pay the buyer's attorney to draft the documents or they're going to pay their own attorney to draft the documents. You don't pay both.
Right.
So it's totally up to you and totally personal preference. But if you start selling houses down in Fayetteville, Southern Pines, Pinehurst, don't be shocked when everybody has their own attorney. That's just how they do it down there.
Yeah, here, because I'm in the, I don't venture out of my little play area, but I just essentially present to my clients, it's your option. My recommendation is this, but you have to make the decision because I don't kind of want to get backed in that corner. But I think along the same terms that you did, I just didn't know if that was best practice in your opinion. So thank you.
I think, yeah, having conversation is always the best thing to do.
Okay,
Yeah.
great. Thank you.
You're welcome.
I had a question about, like, if you're getting ready to list a home and there is a potential lawsuit or legal dispute brewing in the background. So like in this example that I have, nobody's filed anything, but two sides are talking to attorneys and are angry with how something in the past went down. How does that affect, when we can list it, or what should be disclosed, or what do we have to be careful in regards to that? Or can anything pass on to the new buyer, or not really?
Property only attaches to a clocked like judgment. So if the lawsuit is pending at the time, it depends if the property is involved as well. So if it's a lawsuit and it's individuals suing each other over a contract dispute, the property doesn't get looped in there unless there's a clocked judgment against it. So if the lawsuit's still going on, it doesn't harm the person's ability to sell their property. If the property is involved in the lawsuit, like it's then it's a different story. So it's going to be a little bit situational. So you'll just want to make sure you understand what the lawsuit's about. If your client is just getting sued by Discover Bank because they stopped paying their credit card payment, that's not going to affect them to be able to sell the property unless that lawsuit turns into a judgment prior to closing. Then you got to pay off the judgment. But so just ask questions.
So like a landlord tenant dispute type of thing. I mean, was about the property, but it's really about the agreement that they had between them.
Exactly. And so it very likely will not affect the property. On it because it's a personal, it was like rent not being paid or something. So it will not attach to the property.
Okay. Thank you.
You're welcome. All right. I think we're good, Kate. What do you think?
Awesome. I think we covered it all. Thank you so much. I know there's a lot of little technicalities in there, and inevitably, even though we've heard it, we're still going to be calling you when they come up, as you should, as we should. And that's exactly why they're here. But hopefully, that gives you a little peace of mind and that you learned a good bit today. Cara, thank you so much for doing this for us and for always being a resource. Y'all are amazing. And while I have you, I'll send you an email afterwards. But if you could send that staggered due diligence agreement our way, I'll be sure to include it in there when the recording goes out so everyone has it.
You got it.
Awesome. Thanks, y'all. Have a great day. Bye.